Welcome to Chapter 14 of Criminal Procedure, Sentencing and Appeals. This chapter completes our survey of the criminal justice process by examining what happens after a defendant is convicted. First, we look at the sentencing decision itself, the history of sentencing philosophies in the United States, the purposes punishment is meant to serve, the major approaches to structuring sentences, and the constitutional limits on punishment imposed by the Eighth Amendment. We then turn to the mechanisms for challenging convictions, direct criminal appeals, and the writ of habeas corpus. Throughout this chapter, as in every chapter of this course, we see the same central tension, the balance between the societal interest in finality and the enforcement of criminal law on one hand, and the protection of individual rights on the other. That tension is especially acute at the sentencing and appellate stages, where the consequences of error are more severe. Chapter 14 has 9 learning objectives covering the full arc from sentencing through appeals and habeas corpus. Objective 14.1 traces the history of sentencing in the United States from the harsh common law punishments of the colonial era through indeterminate rehabilitation-focused sentencing, and then to the modern shift toward determinate sentences and mandatory minimums. Objective 14.2 addresses how courts distinguish civil penalties from criminal punishment, a distinction that matters for constitutional protections like double jeopardy and ex post facto. Objective 14.3 surveys the 4 major approaches to sentencing: determinate, mandatory minimum, indeterminate, and presumptive guidelines. Objective 14.4 covers the judicial sentencing process, the pre-sentence report, the sentencing hearing, the right of allocution, and victim impact statements. Objective 14.5 addresses federal and state sentencing guidelines, including the landmark Supreme Court decisions transforming them from mandatory to advisory. Objective 14.6 covers determinate sentences, particularly mandatory minimum drug sentences and their evolution from the Rockefeller drug laws through the First Step Act. Objective 14.7 covers the Eighth Amendment cruel and unusual punishment prohibition, methods of execution, capital punishment, proportionality doctrine, and life imprisonment for juveniles. Objective 14.8 covers the Equal Protection Clause's role in criminal sentencing, including the difficulty of McCleskey v. Kemp and the Racial Justice Acts. Objective 14.9 covers criminal appeals, the right to appeal, the final judgment rule, interlocutory appeals, the plain error and harmless error doctrines, the automatic reversal rule, and habeas corpus. This slide provides the historical and philosophical foundation for the rest of the chapter. The history of sentencing in the United States moves through 4 broad phases. In the colonial era, the English common law approach dominated. Felonies were capital offenses, and minor offenses were punished publicly through flogging, stocks, and the pillory. The religious character of many colonies added moral offenses to the list. Quaker reformers, particularly Benjamin Rush, argued for a more humane approach in the late 1700s. Pennsylvania established the first penitentiary system in 1790. The word penitentiary literally means a place to do penance, built on the belief that incarceration combined with hard work, Bible study, and personal reflection could reform criminals. By the late 1800s, reformers were arguing for indeterminate sentencing, prison terms with no fixed end date, with the decision when to release left to parole boards that could evaluate an individual's rehabilitation. By 1922, 37 states had adopted this approach, but critics argued that indeterminate sentences gave unaccountable power to unelected judges and parole boards, produced wildly inconsistent results, and failed to deter crime. The backlash came in the 1970s. California introduced determinate sentencing in 1976, declaring that the purpose of imprisonment is punishment proportionate to the offense. Minnesota followed with sentencing guidelines in 1980, and Congress established the federal sentencing guidelines in 1984. The 5 purposes of punishment are fundamental to everything judges and legislators do in this area. Retribution is the most intuitive. Criminals deserve to suffer proportionate consequences for what they did. Deterrence uses the criminal justice system as a warning system. both specific deterrence targeting the individual offender and general deterrence targeting the broader population. Rehabilitation treats criminal behavior as a problem that can be fixed with the right intervention. Incapacitation accepts that some offenders cannot be deterred or rehabilitated and focuses on removing them from society. And restoration, which has grown in importance through the restorative justice movement, focuses on repairing the harm done to victims and communities. The tension between these purposes is constant. A sentence that maximizes rehabilitation might be insufficient from a retribution or deterrence standpoint. A sentence that maximizes incapacitation through a lengthy prison term might destroy any possibility of rehabilitation. There are four major approaches to structuring criminal sentences, and many jurisdictions use a combination of them. Determinate sentences give the legislature, not the judge, most of the control over how long someone serves. A statute specifies a particular penalty, and the judge has limited discretion to depart. The critical constitutional development is that any fact that enhances a sentence above the statutory maximum must be found by a jury beyond a reasonable doubt, not by a judge on a preponderance of the evidence. This is the rule established in Apprendi v. New Jersey in 2000 and extended through Blakely, Booker, Alene, and other decisions we'll discuss on the next slide. Mandatory minimum sentences require a judge to impose at least a specified minimum term, regardless of the individual circumstances of the offender. No exceptions are permitted unless the prosecutor certifies substantial assistance or the defendant qualifies for a safety valve for the first-time low-level nonviolent offenders. Indeterminate sentencing is the historical rehabilitation model. The legislature sets a range, the judge sentences within that range, and a parole board determines the actual release date based on demonstrated rehabilitation. Most states have moved away from pure indeterminate sentencing. Presumptive sentencing guidelines, the federal model, use a commission's formula based on offense severity and criminal history to produce a recommended range. Post-Booker, federal guidelines are advisory and not mandatory, and appellate courts review sentences for their reasonableness. On the judicial process, the pre-sentence investigation report is the central document. Compiled by a probation officer, it includes the defendant's criminal history, financial situation, circumstances of the offense, victim impact, and available sentencing options. In most jurisdictions, defendants have the right to inspect this report for accuracy. In capital cases, the constitutional right to inspect is required under Gardner v. Florida. The sentencing hearing is a critical stage of the criminal justice process. The Supreme Court held in Mempa v. Ray in 1967 that the Sixth Amendment right to counsel applies. The defendant has a right of allocution. The right to personally address the court before sentencing is imposed. And critically, under Mitchell v. United States, a defendant may assert the right to remain silent at sentencing, and no negative inference can be drawn. Victim impact statements have been a significant development. In Payne v. Tennessee, the Supreme Court upheld their use. The court should hear about the human consequences of the crime. But in Bowes v. Oklahoma, the court clarified that Payne does not open the door to family members' opinions about the appropriate sentence. That would essentially give the victim's family a sentencing role. The history of the federal sentencing guidelines is really the story of the Supreme Court's effort to reconcile the Sixth Amendment right to jury trial with the power of legislatures to structure criminal sentences. The Sentencing Reform Act of 1984 established the U.S. Sentencing Commission and mandated the development of binding federal guidelines. When they took effect in 1987, judges were required to sentence within a narrow range based on a mathematical grid combining offense severity and criminal history. Departures required written justification and were subject to appeal. Apprendi v. New Jersey in 2000 was the first major rupture. The Supreme Court held that any fact other than a prior conviction that increases the penalty beyond the statutory maximum must be submitted to the jury and proved beyond a reasonable doubt. The court drew on the constitutional tradition of jury trial as the ultimate check on governmental overreach. Blakely v. Washington in 2004 applied Apprendi to a state guideline scheme. The judge had found deliberate cruelty by a preponderance of the evidence and sentenced Blakely to 90 months when the standard range was 53. The Supreme Court held this violated the Sixth Amendment. The facts that authorized the elevated sentence had to be jury found. United States v. Booker in 2005 applied Blakely to federal guidelines. Justice Stevens' plurality found the guidelines unconstitutional as applied to enhanced sentences based on judge-found facts. Justice Breyer's remedial opinion provided the solution. Sever the mandatory provisions and treat the guidelines as advisory. Judges must calculate the guidelines range as a starting point. Consider it seriously, but may then impose a different reasonable sentence. The trio of cases from 2007, Rita, Gall, and Kimbrough, fleshed out the new advisory regime. A sentence within the guidelines range is presumptively reasonable on appeal, though not automatically so. A sentence outside the guidelines is not presumptively unreasonable, but will be reviewed for reasonableness. Appellate courts must give substantial deference to trial judges who can see the defendant and the evidence firsthand. And in Kimbrough, the court held that a judge may disagree with a commission policy judgment, like the disparity between crack and powder cocaine, and impose a below-guidelines sentence on that basis. Allain, in 2013, rounded out the framework by extending the rule to mandatory minimums. Facts that trigger a higher mandatory minimum, like finding that a defendant brandished rather than merely used a firearm, must be found by the jury and not the judge. Mandatory minimum drug sentences are one of the most controversial features of the modern American justice system. The mandatory minimum era in federal law began with the Anti-Drug Abuse Act of 1986. The act created the infamous 100-to-1 disparity between crack and powder cocaine. 5 grams of crack triggered the same 5-year mandatory minimum as 500 grams of powder cocaine. This disparity had devastating effects on African American communities because crack cocaine was predominantly sold in small quantities in urban black neighborhoods, while powder cocaine was more commonly used by white defendants. The racial impact was not subtle. Roughly 3/4 of those sentenced under the crack minimum were black. The Fair Sentencing Act of 2010, signed by President Obama, reduced the disparity from 100-to-1 to 18-to-1. The First Step Act of 2018, signed by President Trump, applied these reforms retroactively, allowing thousands of individuals sentenced under the old law to petition for sentence reductions. The arguments for mandatory minimums are primarily about deterrence and uniformity. If the penalty is severe and certain, the argument goes, rational actors will be deterred from selling drugs, and mandatory minimums prevent judges who might be lenient from undermining legislative policy. The arguments against are powerful and were widely shared across the political spectrum by the time of the First Step Act. The most fundamental problem is inflexibility. Judge John Gleeson's opinion in United States v. Dossie captures it perfectly. Jamel Dossie acted as an intermediary in 4 hand-to-hand crack sales totaling $140. 2 of the sales were slightly over the 28-gram limit. The judge was compelled to sentence Dossie to 5 years in prison. As Judge Gleeson said, just as baseball is a game of inches, our drug offense mandatory minimum provisions create a deadly serious game of grams. The other major problem is prosecutorial manipulation. Drug kingpins who have information to trade can negotiate their way to reduce sentences. Low-level street dealers with nothing to offer have no leverage. The law that was supposed to target the leadership of drug organizations falls hardest to the bottom. The Eighth Amendment's prohibition on cruel and unusual punishment has 2 major applications: the method of inflicting punishment and the proportionality of the punishment to the crime. On methods, the historical certainties are clear. The Eighth Amendment prohibits punishments that were considered cruel at the time of ratification: burning at the stake, crucifixion, breaking on the wheel, drawing and quartering, the rack, and the thumbscrew. These are categorically off the table. For modern methods of execution, the constitutional standard is evolving. Shooting and electrocution have been upheld. Lethal injection became the dominant method between 1976 and 2006. 838 of 1,016 executions used lethal injection. In Bays v. Rees in 2008, the Supreme Court upheld Kentucky's 3-drug protocol. In Glossop v. Gross in 2015, the court established the test for challenges to execution methods. The inmate must demonstrate both a substantial risk of severe pain and that there is a known, available, significantly less painful alternative. Oklahoma's use of midazolam as the first drug was upheld 5-4. The drug shortage crisis created significant controversy. European pharmaceutical companies refused to sell sodium thiopental and pentobarbital for executions. States experimenting with new protocols saw botched executions. Clayton Lockett's execution in Oklahoma took 43 minutes. Joseph Woods in Arizona took nearly 2 hours. States began authorizing backup methods, including firing squad. On capital punishment, proportionality, Furman v. Georgia in 1972 was the pivotal moment. 5 separate opinions condemned the arbitrary and discriminatory application of the death penalty. Justice Stewart's comparison to being struck by lightning remains one of the most memorable images in constitutional law. States responded by adopting mandatory death penalty statutes, which the court then struck down in Woodson v. North Carolina in 1976. Mandatory schemes treat all homicides as identical and prevent individualized consideration. Gregg v. Georgia in 1976 approved the bifurcated sentencing model that most states follow today. A separate sentencing hearing at which the jury finds at least one aggravating circumstance beyond a reasonable doubt, then weighs it against mitigating factors with automatic review by the state Supreme Court. Ring v. Arizona applied Apprendi to capital sentencing. The jury must find aggravating circumstances, not the judge. Hurst v. Florida took this further. A jury's mere recommendation is not sufficient. The jury must actually make the findings necessary to impose death. The court has also established categorical limits on which offenses justify death. Not rape of an adult, not rape of a child, not robbery, not felony murder absent major participation, and reckless disregard for human life. The Supreme Court has developed a distinctive body of Eighth Amendment doctrine for juvenile offenders, grounded in the fundamental recognition that youth is constitutionally different. 3 differences between juveniles and adult matters for Eighth Amendment purposes. First, children have a lack of maturity and underdeveloped sense of responsibility. They're more impulsive, take more risks, and fail to adequately weigh their consequences. Second, children are more vulnerable to negative influences and outside pressures, especially from family and peers, and have limited control over their own environment. Third, a child's character is not as well formed as an adult's. Their traits are less fixed, and their actions are less likely to reflect irretrievable depravity. The court has emphasized that these conclusions are supported not only by common sense, but by scientific research, including brain science, showing that the parts of the brain involved in behavior control are not fully developed until the mid-20s. Roper v. Simmons in 2005 categorically banned execution of offenders who committed their crime under the age of 18, overruling Stanford v. Kentucky. The court also held in Atkins v. Virginia that executing individuals with the intellectual disabilities is unconstitutional, with Hall v. Florida in 2014 rejecting rigid IQ cutoffs as the measure of disability. Graham v. Florida in 2010 extended categorical protection to life without parole sentences for juvenile non-homicide offenders. Only 129 such prisoners existed nationally, and the court found a national consensus against the sentence. States must provide some meaningful opportunity for release based on demonstrated maturity and rehabilitation, not necessarily a guarantee of release, but a genuine opportunity. Miller v. Alabama in 2012 held that mandatory life without parole for juvenile homicide offenders violates the Eighth Amendment. The critical word is mandatory. The court did not ban life without parole for juveniles convicted of homicide. Rather, it required that a sentencer have the ability to consider the individual juvenile circumstances before imposing the harshest sentence. The sentencer must be able to consider age, background, the nature of the crime, the level of participation, and potential for rehabilitation. Montgomery v. Louisiana in 2016 made Miller retroactive, requiring resentencing or parole considerations for thousands of individuals serving mandatory life without parole sentences imposed as juveniles. Jones v. Mississippi in 2021 pulled back somewhat from Montgomery's implications. The court held that Miller does not require the sentencer to make an explicit finding of permanent incorrigibility before imposing life without parole. It is sufficient that the sentencer had discretion and considered the defendant's youth as a mitigating factor. Justice Sotomayor's dissent argued this gutted Miller's essential holding. Two additional important topics round out our coverage of constitutional sentencing limits: the Eighth Amendment's application to sentences for terms of years, and the Equal Protection Clause's role in preventing discriminatory sentencing. On terms of years, the Supreme Court has been very reluctant to second-guess legislative sentencing decisions. The court's position is that sentence proportionality challenges to terms of imprisonment should be upheld on extremely rare occasions only when the sentence is grossly disproportionate to the offense. The court has consistently upheld even very long sentences under the three strikes laws. Lockyer v. Andrade sustained consecutive 25-year to life sentences for stealing $150 in videotapes. Ewing sustained a 25-year sentence for stealing $1,200 of merchandise. The court's reasoning is that California has a legitimate interest in incapacitating and deterring recidivist felons, and the judiciary should respect legislative judgments about the appropriate penalties. Weems v. United States is the rare counterexample. 12 years at hard labor while monocled at the wrist and ankle, followed by lifetime loss of civil rights for forging a public document. The Supreme Court found this grossly disproportionate in both degree and kind. On equal protection, the rule is clear. Sentences cannot be based on race, gender, ethnicity, or nationality. State v. Chambers in New Jersey illustrated a gendered sentencing scheme that systematically disadvantaged women for the same offenses and was struck down. McCleskey v. Kemp is the most difficult case in this area. The Baldus study was methodologically sophisticated and showed stark racial disparities. Defendants who killed white victims were more than 4 times as likely to receive the death penalty as those whose victims were black. Justice Powell's majority opinion held that this was insufficient because statistical patterns across thousands of cases with different prosecutors, judges, and juries did not establish that the decision-makers in McCleskey's specific case acted with discriminatory intent. The dissenters argued powerfully that the majority was essentially asking defendants to prove the impossible. A pattern of discrimination that is built into the system cannot be demonstrated through individual case-by-case proof. The Racial Justice Acts in Kentucky and North Carolina attempted to address McCleskey by allowing statistical evidence of racial bias as a basis for challenging death sentences. North Carolina's act was repealed after producing several successful challenges. Criminal appeals serve as the primary check on errors in the trial process. Despite the fact that there is no constitutional due process right to a criminal appeal, the Supreme Court has held this is a legislative question. The federal government and every state provide an appeal as a matter of right for felony convictions. 2 important constitutional protections attach once the right to appeal is provided. In Griffin v. Illinois in 1956, the Supreme Court held that if Illinois provides a right to appeal, it cannot condition meaningful access to that appeal on the ability to afford a trial transcript. Indigent defendants must receive a free transcript. And 7 years later in Douglas v. California, the court held that an indigent defendant on a first appeal as of right must be provided with appointed counsel. The right to effective counsel on the first appeal as of right is constitutionally guaranteed. On grounds for appeal, the list covers the full range of constitutional and procedural errors that can affect a criminal trial: improper admission of evidence, Brady violations, double jeopardy, speedy trial, jury selection discrimination, erroneous instructions, ineffective assistance of counsel, prosecutorial misconduct, and evidentiary insufficiency. The final judgment rule is the general procedural principle that defendants may not appeal during the trial, but must wait until conviction and sentencing. The rationale is sound. Piecemeal appeals would fragment trials, create delays, and waste judicial resources. The appeals court can address all errors at once after the trial is complete. But there are 4 categories of interlocutory or mid-trial appeals. Excessive bail is the first, because by the time the case is over, months of improper detention cannot be remedied. Double jeopardy is the second, because the whole point of double jeopardy is the right not to be tried again. You cannot protect that right by waiting until after the second trial is over. Competency to stand trial is the third. Involuntary medication to achieve competency raises constitutional concerns that need to be resolved before trial proceeds. And the speech or debate clause protects members of Congress from being hailed into court for legislative acts, a right that evaporates if a trial proceeds. The raise or waive rule requires defendants to object to errors at trial to preserve them for appeal. If you don't object, you're deemed to have waived the issue. This promotes efficiency and gives trial judges the opportunity to correct errors before they taint the verdict. Understanding the standards of appellate review is essential for understanding how criminal appeals work in practice. There are 3 distinct standards, each with different consequences. The plain error rule is the gateway for errors that were never objected to at trial. Normally, failure to object means the issue is waived, but Federal Rule 52B and its state equivalents provide a safety valve for errors that are plain, obvious under existing law, and that affect substantial rights and seriously undermine the integrity of judicial proceedings. The standard is demanding, and courts apply it sparingly, but it exists to prevent genuine miscarriages of justice. The harmless error standard applies to most constitutional trial errors that were properly preserved by objection. The constitutional standard comes from Chapman v. California in 1967. The error is harmless only if the court is convinced beyond a reasonable doubt that it did not contribute to the conviction. This is the prosecution's burden to meet. The question is not whether the evidence of guilt was overwhelming. The question is whether the error influenced the jury. Many convictions are upheld under harmless error because the court can be confident that the error, while real, did not change the outcome. The automatic reversal rule is the narrowest category, but the most powerful remedy. Some errors are so fundamental to the entire concept of a fair trial that they cannot be subjected to harmless error analysis at all. The question with structural defects is not whether they affected the verdict. They are presumed to have undermined the entire proceeding. The list is deliberately short: denial of counsel, biased judge, racial discrimination in jury selection, denial of self-representation, denial of public trial, incorrect reasonable doubt instructions, speedy trial denial, double jeopardy, and the McCoy structural error where the lawyer concedes guilt over the client's express objection. McCoy v. Louisiana in 2018 is a significant recent addition. Defense attorney Michael Coren, over client Robert McCoy's vehement and repeated objection, conceded McCoy's guilt in opening statement at both the guilt and penalty phases. The Supreme Court held this was a structural error because it denied McCoy the fundamental right to make his own choices about how to defend his liberty. Some decisions belong to the defendant and not to his lawyer. On retroactivity, new constitutional rulings apply to all cases pending on direct appeal, cases in the pipeline. But for defendants who have already exhausted their direct appeals and are seeking habeas corpus review, the general rule under Teague v. Lane is that new procedural rules do not apply retroactively. Edwards v. Vinoy in 2021 eliminated the so-called watershed exception, which had theoretically allowed truly fundamental new procedural rules to apply retroactively on habeas. The court acknowledged that in 32 years since Teague, no watershed rule had ever been identified. The writ of habeas corpus is one of the oldest and most fundamental protections for individual liberty in the Anglo-American legal tradition. William Blackstone called it the most celebrated writ in English law. Its constitutional status is confirmed in Article 1, Section 9, which is the only individual right protection in the original Constitution before the Bill of Rights was added. Habeas corpus operates as a civil lawsuit brought by a prisoner, now called the petitioner, challenging the lawfulness of their detention. The name means you have the body, and the writ is an order to the government to bring the prisoner to court to justify the detention. If the court finds the detention unlawful, it orders the prisoner released. The 4 requirements for filing a federal habeas petition are federal claim, custody, finality, and exhaustion. Federal claim. The petition must be grounded in a violation of federal constitutional law or a federal statute. State law violations are not reviewable. Importantly, a claim of actual innocence alone without a federal constitutional hook is not sufficient for habeas relief, as the court held in Herrera v. Collins. Custody. The petitioner must be in custody, broadly defined to include incarceration, probation, parole, and bail. Even someone who has completed their sentence may still be in custody if there are continuing collateral consequences like loss of voting rights. Finality under AEDPA. The 1996 Anti-Terrorism and Effective Death Penalty Act requires state prisoners to file within 1 year of the final state court review. Congress imposes these time limits primarily to speed up resolution of capital cases, though the statute applies to all habeas petitions. Exhaustion. Before coming to federal court, the petitioner must exhaust all available state remedies. The habeas process is not a substitute for the state appeal process. It is a supplemental check available after the state courts have had their opportunity. The standard of review on habeas is differential. Federal courts ask whether the state court decision was unreasonable, not merely wrong. The question is whether the state court's ruling was so lacking in justification that there was no possibility of fair-minded disagreement. On limits. The Teague retroactivity doctrine, as narrowed by Edwards and Vinoy in 2021, means that new procedural rules announced by the Supreme Court after a defendant's direct appeal are exhausted will not apply in habeas. Substantive rules, those that alter what is criminal or what punishments are permissible, do apply retroactively. Procedural default, successive petition restrictions, and the demanding burden of proof all further limit habeas review. The underlying tension in habeas law is between 2 equally legitimate values: the interest in finality and respect for state court judgments on one hand, and the interest in correcting constitutional errors that have resulted in unjust imprisonment on the other. Let me bring Chapter 14 together with the 6 key takeaways. First, the history of sentencing runs from colonial-era harsh physical punishment through rehabilitation-focused indeterminate sentencing to the modern determinate and mandatory minimum era. 5 purposes of punishment guide sentencing decisions: retribution, deterrence, rehabilitation, incapacitation, and restoration. And different eras have emphasized different combinations of these purposes. Second, the federal sentencing guidelines after Booker in 2005 are advisory rather than mandatory. Judges calculate the guidelines range as a starting point and may impose any reasonable sentence. The Apprendi line of cases, Blakely, Booker, Allain, requires jury findings beyond a reasonable doubt for any fact that enhances a sentence above the statutory maximum or triggers a mandatory minimum. Third, mandatory minimums are constitutionally permissible, but have generated intense controversy. The crack, powder, cocaine disparity, reduced from 100-to-1 to 18-to-1 by the Fair Sentencing Act and applied retroactively by the First Step Act, is the most prominent example. Critics point to inflexibility, racial disparate impact, prosecutorial manipulation, and prison population explosion. Fourth, the Eighth Amendment sets constitutional limits on punishment through evolving standards of decency. Lethal injection is constitutional under Glossop's 2-part test. Capital punishment requires bifurcated sentencing, jury aggravating circumstance findings, and may not be imposed for non-homicide offenses or on juveniles or intellectually disabled defendants. Miller prohibits mandatory life without parole for juvenile homicide offenders. Montgomery made this retroactive. Jones v. Mississippi held that no explicit finding of incorrigibility is required beyond consideration of youth. Fifth, equal protection bars race, gender, or ethnicity-based sentencing. McCleskey v. Kemp requires proof of discriminatory intent in the specific case. System-wide statistical evidence is insufficient. Three strikes laws are upheld under the deferential proportionality standard, which requires gross disproportionality to justifying judicial intervention. Sixth, criminal appeals are universally provided for felonies, though not constitutionally required. The plain error, harmless error, and automatic reversal standards govern review of trial errors. Habeas corpus under the AEDPA provides a collateral civil remedy with strict requirements: federal claim, custody, exhaustion, finality, and is limited by procedural default, successive petition restrictions, and Teague's retroactivity doctrine, which Edwards v. Vinoy in 2021 stripped of its watershed exemption entirely. That concludes Chapter 14 and the course curriculum covered in this lecture. Thanks for watching.